Over the next 15 minutes, I want to speak about some of the modern challenges we face in the law of the sea, and some of these topics will be explored further in later presentations. But for the moment, I want to give a very general overview of what I see as being some of the key issues. So I'll be talking about the management of our maritime commons, boundary disputes, weapons proliferation, piracy, seabed mining, human rights, and information sharing, before turning to a few uniting themes. So let's consider some of the questions about managing our maritime commons and maritime resources. In particular, one issue that's been in the news a lot has been Japanese whaling. And this gives rise to a couple of questions. First, there's been a case taken by Australia against Japan at the International Court of Justice based on the claim that Japanese scientific whaling is in violation of the International Convention on the Regulation of Whaling. One of the difficulties in that convention is going to be that Australia wants to plead other international instruments in that litigation, including the Convention on Biodiversity and the Convention on International Trade in Endangered Species. And Japan can object that neither of those two treaties actually have dispute resolution clauses giving jurisdiction to the International Court of Justice. So it will be interesting to see if Australia can rope in broader principles from other instruments. There's also, of course, the question of protest at sea and efforts to draw international attention to Japanese whaling by groups such as Sea Shepherd, whose vessel the Steve Irwin is pictured here. So one question that's arisen has been, well, if Sea Shepherd crosses a certain line, if their protest becomes violent, are they pirates? And in a United States case, Cetacean Research and Sea Shepherd, the Ninth Circuit of the Federal Court held that in fact that was possible and that injunctions could be issued against Sea Shepherd. So at international law, piracy is any act of violence, theft or detention committed on the high seas by a private vessel against another vessel for private ends. So the debate turns on the question, is political protest an act for private ends, or do political acts not constitute piracy in that sense? And what the Ninth Circuit held was that Sea Shepherd's acts could be piracy because for private ends means not sanctioned by a state. So the contrast is private and public. But this gives rise to the possibility that if Sea Shepherd could be pirates, so perhaps could Japanese research vessels if they use excessive force in repelling protest vessels. So it'll be very interesting to see how those issues play out. Also, there's been considerable concern in Africa about illegal, unreported and unregulated fishing in their exclusive economic zones by other states coming from all over the world, European states, North American states, Asian states. And so another interesting question that's going not to dispute resolution per se, but the International Tribunal for the Law of the Sea for an advisory opinion, is the question of what are the responsibilities of flag states when it comes to the prevention of illegal, unregulated and unreported fishing. So the Sub-Regional Fisheries Commission has asked for such an advisory opinion, and the SRFC is an African fisheries body. So two interesting questions to look out for. Another major issue is boundary disputes, and the hot one at the moment is the South China Sea. And here in slightly clearer detail, the so-called 9-dash line that appears on certain Chinese maps and that would appear to assert some kind of legal claim on behalf of China to large areas of the South China Sea. Now, obviously, that 9-dash line comes very close to the waters of neighbouring states, and in particular the Philippines. And the legal status of that 9-dash line, even in Chinese scholarship, remains unclear. It may be an assertion to, as it were, special historic rights in these areas, a claim which is difficult to sustain under the UN Convention on the Law of the Sea, or it may be an assertion that this is roughly where, in any delimitation, maritime boundaries should fall, which again might have some difficulty on conventional principles. But what to do when you're confronted by what seems an excessive claim by a major power in your backyard? Well, the Philippines is attempting to invoke arbitration under the UN Convention on the Law of the Sea. And that will be very interesting to see how it plays out, because China has a reservation saying that such arbitrations, it gives no consent to such arbitrations when they concern maritime boundary disputes. But the Philippines is trying to frame its case as China is interfering in our enjoyment of our exclusive economic zone by this excessive claim. So it will be interesting to see how that is resolved by an arbitration panel if it finds it has jurisdiction over the dispute. Another question that's concerned the law of the sea for some little time, principally since 2003, is the issue of weapons proliferation by sea, and in particular the fear of the spread of weapons of mass destruction and associated technology by sea, which led to the formation of the Proliferation Security Initiative in 2003. The PSI isn't a treaty, it isn't an organisation, it's a group of politically like-minded states that are concerned with this issue. And one of the things the PSI signed up to do was to strengthen relevant international law dealing with WMD proliferation. So in particular, if you're looking to strengthen international law, you might think about treaties, you might think about Security Council resolutions. And interestingly, neither of these has perhaps had the impact that was feared. That is, some scholars thought that efforts to counter proliferation of WMD by sea would result in interferences with the freedom of navigation, a principle that forms the traditional lifeblood of trade on the high seas, the idea that only flag states can control the movement of their shipping on the high seas. So, what do PSI states, including the US, push for? Well, there is a treaty. It's a protocol of 2005 to the Suppression of Unlawful Acts Against the Safety of Maritime Navigation Convention. That convention is normally called the SEWA Convention, so the new protocol is normally called the SEWA Protocol 2005. And it creates offences related to WMD smuggling and a system whereby one state could ask another state for permission to board its vessel on the high seas on suspicion of WMD smuggling. However, the effectiveness of that protocol is limited by the fact that at the moment it only has 23 state parties, none of them major naval powers, and most states don't have a domestic law that would make it an offence for a foreigner on the high seas, on a foreign ship, to be transporting weapons of mass destruction or associated technology, potentially to a foreign destination. The US has a law that, subject to certain restrictions, might cover that, but it hasn't ratified the protocol. So the impact on freedom of navigation of the SEWA Protocol 2005 at the moment is quite limited. There are also a variety of Security Council resolutions dealing with weapons of mass destruction. Resolution 1540 targets transfers to non-state actors, 1874 targets transfers to North Korea, and 1929 targets transfers to Iran. But none of these authorise unilateral intervention on the high seas. 1540 doesn't mention interdiction at all. 1874 says that states should consent, flag states should consent to interception on the high seas, but if they don't consent, then their vessels must be directed into port. So again, it doesn't create a unilateral right of boarding. And again, 1929 just notes that states could ask flag states for permission to visit and search a vessel on the high seas. So no unilateral right of intervention on the high seas is created by any of these resolutions, and in each case, the principle of flag state jurisdiction and freedom of navigation is upheld. This contrasts with the problem of small arms and light weapons. Basically, the story here is that there are numerous international instruments, both legal and political, that target the SALW trade, but they tend to be quite weak in terms of enforcement, and none of them specifically address maritime traffic. So there's no comparable treaty even to the SEWA Protocol. There are some UN sanction regimes that have included a maritime interdiction component aimed at small arms and light weapons, largely between 1990 and 1997. So the examples being the sanction regimes against Iraq, the former Yugoslavia, Haiti and Sierra Leone in times of conflict. So again, the targeted sanctions perhaps go further than Security Council resolutions dealing with weapons of mass destruction, but are very conflict specific. So if we look at the situation of weapons proliferation by sea overall, we see a WMD regime that has patchy and limited impact, and a small arms and light weapons regime that's perhaps even more limited, despite really the graver threat posed to more people on a daily basis by small arms and light weapons proliferation. And all of this suggests that the principle of the freedom of navigation is one that states are keen to uphold, including powerful states that might feel threatened by weapons of mass destruction, such as the United States. And that makes sense, because the principle of the freedom of navigation underpins their own trade and their own economic security, and creating a new principle that allowed interference with it would not necessarily serve their interests. Piracy in the Gulf of Aden and off Somalia has been of significant interest in recent years, and what's most interesting about it is the shift from a military paradigm, one based on naval patrolling to deter pirates, to a law enforcement paradigm, and increasingly a response with a strong component from the shipping industry itself. So we now see a lot of law enforcement cooperation. So patrolling navies will apprehend suspected pirates and then transfer them to regional states such as Kenya, the Seychelles, or Mauritius for trial. And those states where they convict pirates now have, in many cases, transfer arrangements in place such that any convicted pirates can serve their sentence in UN-built and monitored prisons inside Somalia. All of this has required capacity building, both in regional prosecuting states and in Somalia. Also, industry has responded with its best management practices about making vessels more secure from pirate attack, and rather more actively, there's been the rise of privately contracted armed security personnel being embarked as a counter-piracy measure on commercial vessels, giving rise to a range of legal issues. Deep seabed mining is another interesting question. It's been on the agenda for quite some time, and the thought has always been that it hasn't been economically viable, the technology hasn't quite existed, but there's now a new wave of licensing and exploration underway. So some examples include the Canadian firm Nautilus Minerals is exploring the possibility of mining polymetallic nodules from the seabed floor in the exclusive economic zone of Papua New Guinea. The International Seabed Authority that licenses deep sea exploration beyond exclusive economic zones adopted new prospecting regulations in 2012. Exploration licenses granted by the ISA in the Clipperton Zone have included one to the UK firm Seabed Resources, a subsidiary of Lockheed Martin. So it's an issue that's being taken far more seriously by commercial players. Also, once again, there's an International Tribunal for the Law of the Sea advisory opinion in the mix. So if you're going to explore under an ISA license in the deep seabed, you have to be sponsored by a state to do so. And some of the states that have entered sponsorship arrangements are developing states like Nauru and Tonga. So they asked the Tribunal for the Law of the Sea for an advisory opinion on their responsibilities for such exploration. And that gives rise to a range of both environmental and regulatory questions, particularly where developing states may have less capacity than some to supervise the activities of these corporations. So this will be another issue to watch very closely. Briefly, human rights at sea is an interesting area. So a number of questions arise here. For example, seafarers have been strongly affected by the rise of security measures post-September 2011. So states, major port states, are very keen on having stronger visa and ID requirements for seafarers, but seafarers, as a human right and safety concern, require access to shore leave. A balance was struck in the Seafarer Identification Document Convention of 2003, which would have introduced biometric seafarer IDs in exchange for visa-free shore leave. However, the approach of a number of major coastal states, including the US and Australia, has been they want both biometric ID and visas in advance for shore leave. So the convention looks as though it may be something of a dead letter. There's also the difficult question of human rights and irregular migration by sea. When migrants are picked up as a search and rescue exercise by boat, that is a fundamental obligation, the duty to rescue people in distress at sea. However, the issue of persuading territorial states to allow those people to be disembarked has been far more complicated. Also, human rights concerns are raised in law enforcement activities at sea. So when Somali pirates are captured or drug smugglers are captured at sea, as happened in the case Medvedev and France, questions arise about their criminal justice rights under those situations, particularly access, for example, to a lawyer or to a judge to promptly review the status of their detention. Finally, a question that arises is information sharing. So everyone is now very concerned about the idea of maritime domain awareness. That is, you can only understand the threats you face at sea if you have some awareness of what ships are actually out there. So the Regional Agreement for Combating Piracy and Armed Robbery Against Ships in Asia, RECAP, and various IMO regional counter-piracy programs are based around the idea of states in a region sharing information with each other. There's also a thing called the IMO Long Range Information and Tracking Regulation, which gathers information about the movements of ships and transmits it to coastal states, for example, through an international data exchange. So this should allow ships that have automatic identification systems to be monitored by coastal states if they're within 1,000 nautical miles of their shore. However, while that should give coastal states a lot of data, small vessels and fishing vessels are excluded from its scope. So it is in fact quite limited because those are the vessels most likely in many cases to be involved in maritime crime. Also, it gives rise to capacity building issues. If you want to share information with developing states or states with poor infrastructure, you have to give them the capacity to gather that information in the first place, or rather assist them to develop it. So what are the uniting themes here? Well, obviously the agenda is driven by the priorities of great powers, but also if you want maritime security, you have to strengthen the capacity of weak states. So there is a need for information sharing, cooperation and capacity building in this area. Also a theme we see running through perhaps these case studies is an expanding role for dispute resolution. States seem more willing at the moment to take certain cases to arbitration or the International Court of Justice, or to seek, if not strictly speaking dispute resolution, advisory opinions from the tribunal on the law of the sea. And that in brief is what I consider to be some of the major challenges at present, most of which we'll explore in future presentations.